used to build my probate-based real estate business is advances in inheritances, helping attorneys move more smoothly, helping families get money ahead of time to get the best result. And while at first blush, many attorneys will say things like it's expensive or the interest rate's too high, the reality is, my experience has been that more customers get better outcomes, at least by exploring the opportunity of advanced inheritances. We're lucky to have today an attorney with one of those firms that I've worked with, actually a sponsor of my Probate.Cash program, Christopher from InheritNow. Christopher, welcome to our call today.
Hi, Bill. Thanks for having me. Appreciate it.
So first off, give a little background. You're an attorney. I think you're based in Pennsylvania?
That's right. I am in-house counsel for InheritNow. I'm a Pennsylvania, New Jersey licensed attorney. That's where I grew up. That's where I grew up.
Major.
I'm hearing some. I don't hear it now.
That was
wow.
That was rough. That was rough.
I just unmuted myself, and then
Yeah.
all of a sudden,
We're good now.
Wow. Okay. So I don't know what it is. Something to do with the sharing or
right.
the.
I think we're okay now, though. Maybe.
Okay. So you licensed in Pennsylvania as an attorney. That's where you grew up?
Yeah. So I'm a New Jersey PA attorney. I got my legal experience first few years in Pennsylvania. I was a civil litigation guy for like a mid-sized firm. I was never a probate guy. Funny enough.
Hold on a second. This is not working. I don't know what we're doing.
Sorry.
No, it's not your fault. There's something I've changed a couple things on my computer. I'm going to go back to what I've done before. I'm going to jump out the call and come back on. I'm going to cancel the Zoom and hope you all stay there. I'll be back.
I'll be here.
Sign. I'm going to leave it to you.
I guess I'm running the show now.
I guess you are. I'm Jess. I'm Bill's assistant. I
That's
popped on camera. Yeah, I'm like, oh, okay, there's some audio issues happening today.
That one was scary for a second. I was like, I thought I was in like a feedback loop.
Yeah, I was like, is it just me? I was like, I'm like, do I need to text Bill? Like, am I going crazy? Like, what's going on?
Yeah, I just stopped talking because it just kept going.
Anything's better than the Zoom bombers. Some of our like regulars, Winston knows, there's like, we had some real intense Zoom bombers for a while.
Yeah.
They were like putting their names in as other people's names. So it was hard to tell, like, you know, it's like, oh, we know Winston's name because he's on the call every week. And so, but now there's two Winstons and one is playing adult content on screen share. And how do we get them out without kicking the real Winston out? And it was crazy. So we locked down the security stuff, but apparently we've somehow created audio issues. That's fine. Tech.
Do you need me to admit people? It looks like I don't know, I'm the host right now. I don't want to.
Yeah, you can let people in. That's totally cool.
All right.
Bill should be back in a minute. He's probably just logging out and back in.
So Bill will be back, right?
Bill will be back.
So.
All right.
Otherwise, I'm just here.
Otherwise, you're here. Yeah.
Yeah.
Chris, if you want to continue on with your background until Bill shows up, I think that's what he would do.
Oh, here he is anyway.
Okay.
I still have some tremendous feedback. I don't know what in the world.
We don't have feedback for the rest of us, or at least
hear
I am hearing everything loud and clear. So no feedback.
Okay. So let's continue then. I'll just find some way to deal with it. So you mentioned how you got your license, New Jersey, Pennsylvania.
Right.
How'd you end up in a company that does inheritance advances?
Yeah, so I was a civil litigation guy. I was in a mid-sized firm on partnership track, you know, doing everything from eminent domain suits with Amtrak and PP&L to, you know, landlord-tenant law disputes, like everything. I mean, I was not getting any specialization. I was just getting the full litigation experience. I'm a great researcher. That's one of I think my best skill sets. I'm really good at legal research. So I was just pulled in all sorts of directions by anyone who needed me. And that kind of burnt me out a bit. And I didn't see myself being a partner there in like a track that I liked. And so I have a pretty unique, actually, I think, you know, first few years as an attorney, I just stepped away from law for 3-4 months and decided to go travel the country for a few months. And that's what I did. Didn't know what I wanted to do. I didn't want to be a litigation attorney at that firm, and just nothing was, pulling my heartstrings. So I just took some time off, went to like 30 national parks and hiked, and then landed in a sort of general collection space, almost managing collection spreadsheets as just something I just needed a job again. And this opportunity almost fell in my lap, and it was just a perfect fit to be in-house counsel for this company. And we have a parent company that I do some things for here and there, but it was just a perfect match between my CEO and the, more global counsel, that they needed someone that could problem solve and that knew how to get money, but they didn't want a probate person. They didn't want an estate attorney. That's not the type of guy they needed there. They needed a litigation guy who could figure out probate. And that's exactly what I was. I know how to get money. I know how to make cost benefit analysis to say it's worth it to sue this person. It's not worth it. That's my bread and butter. All I have to do is now learn probate across the country and see how that fits in and with our contracts and understand that. And so, I'm about 6 months exactly here. And I think I have my feet under me a bit, although, I'll never get cocky because this world is crazy. But so that's my path. I litigated for a few years, took time off, got into some collection space that I was not going to be long term, and it just was a great opportunity that just sat perfectly with them, sat perfectly with me, and I'm happier than ever.
So is the collection part because many of the estates are like lawsuits and the person passes, and how to collect the money the company's buying, or is it the actual process of probate and collecting the inheritance advance that's the collection focus part?
It's a mix of all of those things and more. And so that was another thing. Like, they were looking at collections people who just did straight debt collection, and that wasn't me. I'm a problem solver. And that's what they want, because as you know, this probate world, the problem is most likely different every day. It could range from family disputes to just an administrator not doing their job to, in our case, sometimes, for example, the estate will just distribute the assigned inheritance to our customer, and then we got to go chase the customer and say, hey, that was supposed to be distributed to us. I mean, the list of problems doesn't stop in terms of differentiating problems. So it was really just, they're looking for a problem solver, someone who could research the novel issues, get a basic understanding of probate in 46 states or however many we're kind of participating in. And yeah, it's a problem solving job more so than collection. I don't know, collections is too broad and simplified of a term for what I do. Like, for example, like, I've spent on one issue just dealing with the customer and just people, just kind of dealing with them as a human and just walking them through things and hand holding. I mean, it's so different every day. So
I think that as real estate agents in the probate space, we get paid to solve problems, and so often we mistakenly look for the easy business, but where there is problems, most people can't get over that wall. We solve the problem. That's how we get paid. Now, it's a little different when you work for a company, maybe not. It certainly makes the job interesting that you deal with different things on a regular basis.
Yeah. I would say, though, for the most part, like, if you look at, the book of business in any probate advance company, the vast majority of these advances are no problem. I don't even look at them, and the money comes in, but those problems that do come up require quite a bit of attention and quite a bit of elbow grease. And on top of that, just think about the advance business. There's certainly plenty of customers great people, want money for one reason or another. There's other people who all of a sudden they hear Aunt Sally's going to give them $50,000 and they want it as soon as possible to go buy whatever they want to go buy, and they're going to run away. I mean, so there's that reality of just when you're offering people money before they're supposed to get money, you're going to get a certain category of problems, if you will.
Right. And then part of your business, I'm sure, is just setting up the proper legal operations to do your business, right? So let's start off with that a little bit. On this call, we have 59 people, 60 people from around the country. California, we have a very set process for buying an interest in an heirship. In other states, it's not as developed or procedurized, right?
Right.
So describe what that's like when you go into a new state. Let's say you're advancing for the first time, or you had problems before, and you're going back into a state. It's been a while. What's the process like to find out how they can do the advance and you can protect yourself?
So I'll say there's a few states. California is at the forefront of creating procedures for this industry. California is the first to make a statute on inheritance advances and sort of some minimal requirements that they'd like to happen, or at least providing opportunities for this to be reviewed by the courts. But most other states, I mean, it's the Wild West. There's half of the estate attorneys don't even understand the product. So I'm stuck explaining the product to them, and half of them think it's a loan. And I'm like, there's no loan here. This is not a loan. We purchased a property interest, a portion of a property interest. And so, in those states where there's no, like regulatory scheme like California, like Illinois and New York, or other ones where there's statutes on this, and the probate attorneys are generally aware of it, and there's enough of there's enough players that it's, if you just tighten your contracts up and file them right, it should be fine. But otherwise, really, so how part of an underwriting huge consideration in this Wild West atmosphere of states is that all of these companies had to get together and basically make an agreement as to what happens when all of us advance on one estate, who gets paid. And so we've all the industry players have come together and have this, there's no law, there's no case, there's nothing that any lawyer is going to point to, but we have an industry standard that is a first in time, first in right filing. So if we get to the courthouse first and say, hey, Bobby, assigned us $20,000, but in reality, a month before Bobby contracted with another company, but they didn't file it, everybody's come together and agreed that we get paid first because we came to the courthouse first and filed our piece of paper. And that is a gentleman's agreement across the board. And so you get to these situations in Arkansas where someone, what happens when maybe someone gets money before us and we're supposed to get it. Now it is completely Wild West in these states where there's no scheme, and most estate attorneys are hesitant to respect it. And so when they've never heard of it before, they say, listen, I don't care what you contracted with this customer. I'm giving the money to the heir. You can go deal with it with them. And then we're just stuck in a litigation space, which is crazy. So we really, have most of our advances in the big states where there's like at least some sort of procedure where the court blesses it beforehand. So there's none of this estate attorney at the end of the day, last minute across the finish line, we waiting for a check, and all of a sudden the no check comes and we're scrambling to figure out where the money is. So in California, following. Sorry, go ahead.
I'm sorry. I was just going to explain for those listening. I'm very familiar in California with the process where when you do an advance, the customer signs a contract with you, and then that document gets filed with the court. So everybody's on notice that this has happened. The judge knows it, other heirs know it, objectors know it, the public would know it, other creditors know it. So there's plenty of opportunity to form an argument if it's not valid for whatever reason. And so while there's a procedure and it takes time and effort and energy, on the positive side, it means that there's a process to it that works in California. And to your point about other states, I was invited on a mastermind of attorneys in Arizona. And when I talked about your product, they thought I had invented fire. What? How do you get money before the estate settled? That's impossible.
Right.
And I would say, well, it doesn't matter. If a company's willing to write a check to your client, what do you care? Right? I mean, you should carry a client in general, but just because you don't know it doesn't mean you should get in the way of your client getting a service.
Right. And so, I mean, the other, I guess, flip side of the consideration of when these states, California, Illinois, off the top of my head, where there's these procedures to get your assignment blessed, there's a cost associated with that. I'm not a California attorney. We got to go pay California, a lot of times LA attorneys at that LA cost to go file a document for us, and it costs us money. And so we have to now consider that in our underwriting process of, well, there's an additional cost built into this too, to get it blessed, whereas these other states, we don't have that protection, but it's a little bit cheaper and quicker and easier to do the thing, if you will.
And that's how I really came across your company, was actually you had filed an advance on a case I was involved with. And I saw the documents through how they were done. They were done by the attorney, which was unusual. Normally they're kind of done behind the attorney's back. In this case, you'd use the attorney as the conduit. And I thought, well, that's interesting. And number one, I wanted to reach out to that attorney. Number two, I wanted to reach out to you to find out more about how you operate. So for those of you listening on the call, this is live on Zoom. We also live stream it onto Facebook, LinkedIn, and YouTube. If you're watching on the social medias, feel free to put comments in. If you're watching live, we'll keep them on watching for those. If you're on the recording, I'll try to come back to them and answer them or refer them to Christopher as appropriate. And the other thing I would say is I have a separate call I do every week on Wednesday mornings at 8:30 called getprobate.cash. And I actually do this in conjunction with one of Christopher's colleagues from InheritNow, where we train, explain, and try to educate realtors, investors, and attorneys on how to use this product. Because I do think it's underutilized, and a lot of it's because a lot is not known about it. And that's why I want to bring it to your guys' attention. So in some ways, Christopher, you're kind of like a realtor in that in some states, you're not licensed, you can't do legal work, but you have to learn the legal process. You have to follow the business process. You probably have to negotiate or argue with somebody who is an attorney or is an attorney in that state. So let's talk a little bit about how do you learn about all these other areas? Is it just case by case? You open up that state's probate code, or do you have classes you've taken? Do you network with a bar association? What are things you do to learn in these different jurisdictions?
Westlaw is my best friend. Westlaw is my right-hand man, and Westlaw is my best buddy in the whole world. All day, every day, even if something just comes to my head and I am like, oh, in Illinois, it's this, is it the same here? I'm just constantly making connections and building my own sort of law that I use. But it's mostly case by case that I'm researching based on the issue, because there's so many moving parts all day, every day, that I frankly don't have 3 hours every day to just get up to speed. And so I just have to pick topics and problems that I see recurring, and then just go to the states where we have the most volume and just try to get a handle on it. I mean, I'll tell you, I'm still trying to figure out homestead in Florida, still trying to figure it out. It's a struggle. I mean, I get basics of it, and how we get around it, it's a constant thing. And I will say that a little bit of my, so I'll hire local attorneys in Florida, California, Texas to do piecemeal things, or to just file things, and I'll often just run things by them, and I've in conversation with one of our Florida attorneys about maybe a potential new process for Florida that might help us avoid some issues. And so I do lean on a little bit of my partners, but to be frank, I'm just researching, and that's my best skill, and I think that's where my time is best spent, and I'm building my own treatise, if you will, in a sense, as time goes by.
So for those who don't know, Westlaw is a legal research tool, and I imagine today it's all online. When I was in college, I clerked for my father, who was an attorney, and one of his partners. And those days, Westlaw was a series of books, and every month you get the updates, and then the intern's job would be to take the notebooks and update with the new sheets, pull out the old sheets, not lose anything. And now I'm sure it's all searchable, and you probably carry it on your phone wherever you go. So you're really talking about being able to research the law. But we as realtors can do the same thing to a degree. There is in California a lot of probate code you can research, and I'm not suggesting we do that to advise our customers legally, but at least on our procedures, if it gets down to how to sell a house at court with court approval, all that's online. It's in English. And I remember I've had an attorney say to me, well, you're not an attorney. How do you know that? It's in English. I had the probate code book. It's right there on my bookshelf. You know, you open it, you read it. It's not that complicated. I don't know all the constitutional law foundations behind all this, but I know that it says if the commission is based on A, B, and C, I can add A, B, and C together and make a decision. And so I imagine a lot of your business, Christopher, is really just taking these states that you're not an expert in and applying your research expertise, and then trying to get the local attorney or the local client to understand that you know what you're talking about, right? And for those listening, this is why I wanted to interview him, was it's not that different than what we do, I don't think. It's just he's an attorney, right? To some degree?
Yeah, no, I'd say that's generally fair assessment of it. Yeah.
So where do you see people using the inheritance advance and making a mistake with it? I mean, I'm sure you see cases where they're not entitled to the heirship and the inheritance, and that's an underwriting problem for your company. Do you see cases where people regret advancing the money because it worked out against them? I mean, I know there's a fee they have to pay back on top of the advance, but they didn't have the use of the money. Do you see that very often?
You mean sort of like a regret type thing,
Mhm.
like they regret doing it? I think there is a small element of customers who don't care, don't read until at the end of the day we tell them how much their rebate is, and then all of a sudden I didn't read that, you know, which is you're going to have in any sort of loan or advance. But I wouldn't say there's much of a regret pattern of like, you know, I mean, I will say, like, we had a fellow who we gave quite a bit of money to at the end of his life. You know, he's suffering from cancer, and he passed away before the estate distributed to us. So now, you know, but that was great for him. He got all of his money that he could use during his life, and he would never have seen that inheritance. So, you know, there's that aspect where we made the quality end of this man's life quality pretty fantastic comparatively in terms of finances.
Right.
So I don't see more of a regret, but I do see there's a certain category of people who don't care, don't understand until it matters to them at the end of the day. If that makes sense. I do see people who take advantage of their position in the estate and cause problems that end up causing them problems. But yeah, not so much in the regret space, I would say.
And on the opposite, I would say I see people who find the advance as a life-changing positive, where rather than waiting for a year to get life-changing money, they get some of the money ahead of time. I had a client recently who was inheriting a $500,000 property, and we just sold it. But before we sold it, she wasn't going to get the proceeds until we closed the probate, which is still months away. And her aunt, who had raised her like a mother, passed, had no money for a funeral. She was, you know, this is a woman who was basically living on welfare. And we advanced her $10,000 that she used to do what she wanted to do for her aunt or her mother figure. And she was on the phone crying to me. She was so appreciative that I had done it. I didn't do anything. I just introduced them to an advance company. So I think that's the positive side that I don't know if you see that as an attorney, but I know that goes on in your industry.
I've had a few pretty heartwarming responses. One, like, we funded basically the first 2 years of this woman's daughter's college. She wasn't going to see that much. She would have had to taken out these big old loans with interest, and she did not have to worry about that. And her mother emailed me every other day for 3 weeks, thanking me for helping get it through and, you know, figuring it out and whatnot. Overwhelmingly, it's positive responses from people who are in need of money, and the probate process takes quite a long time, or they have a sibling who's hostile and causing problems, and it's not their fault, you know.
Yeah, I think that's why I've really enjoyed getting into this space. So everybody on the call, this is meant to be participative. Feel free to raise your hand or put a comment in the comment box. And then again, if you're watching, I saw on the YouTube, we got a couple comments. One was they remember the books, but they remember there was a competing product, which is Shepherd's, which I remember that also. That was the law firm I was in had a lot of books, and they had both subscriptions. I forget which one was Shepherd's, but Westlaw was like the main one, I think.
They're actually, it's a combined thing. The Shepherd's is like the citation checking aspect of Westlaw.
I think they bought them. I think there was at one time too.
Yeah, there's some
Westlaw
sort
made
of
all the money.
foundation. So yeah, you look up, you know, Joe Smith versus Bob Smith, and it'll tell, every point of law that case made. It will say overruled or upheld, or, you can find anything. It's fantastic. Yeah.
And now you're just doing it on your computer screen or your phone, probably, or tablet.
I'm on my computer. Yeah, I'm on my computer, and then you can download cases. And the biggest, any practicing attorney knows that secondary sources are where it's at. If you have Westlaw and you have access to secondary sources, that's other attorneys who spend hours reading the probate code and the cases, summarizing the main points of law that then you can go click into and get into the details. It's an absolute game changer for attorneys.
And I just encourage every agent in this space to take the time to try to learn some of this and make an effort, buy a book. I'll never forget, I went to court once and I made a point on how the commission was to be split. And the attorney kind of questioned me, where'd you get that from? And I had been reading off a printer online of the probate code, but I brought the book in my briefcase. I had dog-eared to the spot. And I just pulled it out and said, what's right here in the probate code? And the judge said, well, what is that? It was like 11830.A. The judge looked at it and says, wow, Mr. Gross is right. Okay, very good. We'll change the commission. Yeah.
I would say
that's thrilling.
Get yourself a Uniform Trust and Estates Code book as well, because Uniform Trust and Estates Code is a lot of states basically adopted it and just kind of slapped their name on it, but it's substantially similar throughout most states. So if I have an understanding of UTC statute, well, then every UTC jurisdiction, I know the basics of. I don't need to get into the weeds of, although the UTC is not, it's not going to cover, some of these advanced specific regulations, but it's super helpful to get basics down. So,
and it's written in English.
It is.
You don't have to have a law degree to read the book. They don't check your law license to sell it to you on Amazon, do they? They just sell it to whoever buys it.
Yeah, the only thing being an attorney is just I spent 3 years with people telling me how to read and think about things, but I could still have read it the whole time and figured it out. They just help you figure it out.
And then for this call being participative, the only person on this call who gets a shout out is Winston. Winston Covington's a regular. I appreciate him being on here, but I'm feeling a little lack of love here. Winston gets the hello from Douglas, but I don't get a hello. I don't get anything, let alone Christopher. It's nice to spend time with us today, but Winston Covington, and not even his wife, who's the better half. We got Winston in fact, he's just off the call, I think. So, okay. So in the course of your business, most of your assignments come from attorneys, I think. It's just the way your company is set up, right? As opposed to direct to consumer.
I would say it's a healthy mix, and we also have other non-attorney referral partners like funeral homes and things like that. Certain spaces where you're obviously going to have a source of referrals. So it's a good mix between SEO, attorney referrals, and that.
How about real estate agents?
I'm not aware of that. I'm not on the. I've not heard that being a topic. I'm sure. Well, we have you, but I'm sure there's others out there, but I don't hear that chatter much. So,
and I find it fascinating that we as realtors are out there talking to people who are getting ready to file probate, and we talk to people as soon as they file probate, and when people are selling houses, they talk to us. And again, to everybody on this call, I just think this is such an underserved opportunity for everybody. I really urge you to learn more about it. If I don't do enough to teach you about it, that's on. I'm doing the best I can. Take the initiative and learn about the space. Reach out to the companies involved with it and try to learn more about it and how to be more effective with it. So, some of the times you guys have advances based on an expected inheritance, and it turns out not to be, right? Sometimes, I think there's one that you guys referred that I got involved with where the house wasn't worth as much as we thought it was,
right.
And or the petitioner may or may not have the heirship, may not have the priority or whatever it might be. How often does that happen that you, obviously writing off or mistakes are part of any lender. You don't want to brag about it, but right. Does that happen? Is that a significant part? And what do you do to try to eliminate that?
So it happens. I would say it's not like a significant part. Like if you have 500 advances, I would say there's less than 50 with an issue like that. So, but when you have those issues, they're tough, they're complex, and generally you have to deal with them very quickly. In the space of like the customer isn't entitled to something that we thought at the beginning, we have them do quite a bit of attestations and sort of a warranty thing where we're relying on you, but if someone challenges the will and that's the will they gave and they didn't know of any other will and they end up losing that, because of that will challenge, well, that's a situation where we probably have to cut our loss. But if they lied to us, well, then they committed fraud and then there's a recourse there. But it's not often. I would say it's more often that you have some issue with the asset that we based our advance on. More often than not, the property, the real estate. The real estate's almost always the most valuable part of an estate, and there's generally a few common problems that come up, especially California. If the executor's not doing their job, they're not being diligent, all of a sudden the house is in foreclosure and we're scrambling to try to help stop a foreclosure or to get them to just do their job. And, the last thing we want to do is sue someone for breach of contract. It's the last thing I want to do. So if I can save the property, I will. I think the scenario you were referencing even had a worse problem. We had a foreclosure that we need to sell. And then all of a sudden we realized the house is like down to studs on the inside and there's like no value there. So now we're in the space of, what did the customer know when they came for this advance? Did they know it was down to studs? Do they not? Is it even worth going down that route? Or do we just want to say, hey, executor, customer, do anything you possibly can to sell this, get a builder to assume the mortgage or something? Like, you got to get creative to just save the property because our interest is based on someone else's interest to receive from the estate. But there's no contract between them. They don't owe them money. It's just, if it's there, you get it. It's not like the estate owes them money unless they, do something illegal or breach fiduciary duties and whatnot. But yeah, I would say the estate foreclosure issue is pretty common. And then, just valuation issues. Part of the problem, but it's inherent and it's not really a fix, is that the underwriting process has to be pretty quick because these people are, if we don't give them money in a day, they're going to go to another advance company. So like, you have to balance, like, we don't have time to get an appraisal, right? It's not realistic.
Call us. I'll go look at the property. I'm picking this phone call.
Yeah, in California. Right. But for every advance, like, it's something we discussed and something that underwriting doesn't feel is prudent, because it's going to cost them money. So there's a balance of there's inherent risks of we're sort of just looking at the asset from like a quick overview, or what at like Redfin, Zillow, there's some other services we have, and the representations of the customers, and then you have situations where the customer damages the property. Like I remember a situation where like someone was doing drugs in the estate of property, and then there was contamination, and then they want to clean up the property and spend a whole bunch of money, and like, okay, well, that everybody gets less money now, right? So, and there's nothing I can do to stop that from happening. All I can do is deal with the fallout from the reality, I guess. So those are sort of the main things that come up, like someone damaging the property, us not really understanding the condition of the property, and foreclosures. Like, those are the big three that I see a lot.
I had one with another company. It wasn't you guys, fortunately, where the petitioner really wasn't the child of the decedent. She was raised like one. She referred to the decedent as her father, but she didn't really think through the legal part, or she ignored the legal part. And out of the blue, a blood son shows up and contests the case. Similar case, if you followed the news, Aretha Franklin, where she had apparently a will that was filed in a safe deposit box, not filed, but in a safe deposit box, from like 2010, but they found in furniture of hers after she passed a will she did after that, 2014. Did you hear about this?
No, was it a holographic will, like a handwritten one?
Yeah, handwritten
That's the
will.
classics. Oh, so she did a handwritten will like up 2 months before she died. Like,
Well, this was similar to the one that she'd done 2010, meaning that also was holographic. So
okay.
it wasn't like she had a professional attorney do an estate plan, all that. It was just clear she'd written another version and didn't put it in the safe deposit box for whatever reason. She took it out and left it there by accident. You know, maybe it fell out and she thought she put things away. Nobody knows. She's not around to talk about it. And the judge determined that it was valid and superseded. And though there were certain errors who got written out as a result of that, it was a big deal. It's just fascinating how these everyday problems even apply on very wealthy people who have huge estates.
Yeah. So, I mean, in that situation where there wasn't a fraudulent misrepresentation, the customer totally thought they were going to, we're writing the thing off, or the only other option is to try to muddy the waters enough to settle with the estate and say,
Right.
give us our advance amount back and we'll shut up, you know. But
Right.
even that's a tough sell, like, you know. So, because think about too how much passion there usually is and emotion involved. Like, people fight over the smallest margins just because it's family property and stuff. So you get an outside company in that says, oh, I'm owed part of this. People don't like that sometimes, you know, and they'll just fight you.
The case I had with the woman who wasn't really the daughter, she and the brother kind of made peace on the phone, and he agreed to cut her in for half. And verbally kept saying, yeah, we'll do it. We'll get an agreement. We'll get an agreement. Well, he obviously just was stalling out for time until the judge assigned him, sided with his petition. And once he was in charge, he told her, no, go away. You're not going to get a nickel from me. And so that was a case where the inheritance advance tried to get her with an attorney to represent her to negotiate a settlement. But the customer knew she didn't need the attorney. She knew she could save money. And what she learned the hard way was she ended up with nothing. So it's difficult.
Right. Yep.
Yeah.
Happens. And people like to get greedy.
People get greedy. Okay. So look, we have an attorney here who is licensed in Pennsylvania and a couple other states,
Jersey.
but really in New Jersey, but actually practices the business nationally. So if you're on this call, I saw somebody from Arizona and other states. Not to say he can give you legal advice there, but he has some business advice in most states. Here's your chance to jump in and ask a question. So feel free. I also want to, I was concerned that it was my browser that was the problem, but I'll go back and see if I can do this without creating the audio feedback. But the company that he is the chief counsel for, is that the right name, title?
Legal counsel is my title. They haven't given me general counsel yet. Maybe at the full year mark, I'll general counsel, but it's just legal counsel, in-house counsel.
In this space of inherit advances with InheritNow, InheritNow.com, and they're a vendor that I've worked with and work in my preferred vendor in that space. Actually, my exclusive first advances are with them because they're also helping me with our program, GetProbate.Cash. So if you want to learn more about that, sign up for that program. You'll get a link to a video I did that explains in detail, even if you'll come to the live stream. But they do a really good job, and I feel really comfortable recommending them. But you have an expert here. So if you have questions, again, if you're watching on the live stream, hello from Gilbert, Arizona. Roy, nice to have you on the call. And feel free to jump in the questions.
Question, please.
Anybody have any? Jimmy?
Yeah, thank you, Jimmy in Virginia.
Jimmy in Virginia. What part of Virginia, Jimmy?
Thank you, Bill. Can we back up a little bit just to first principles on how explaining to the potential, let's call it beneficiary, that this is not a loan, but just explaining how this is I heard the term purchasing a property interest. It's, an assignment. It's not a loan. Can you just take it at the highest level on you know, like what is this interest that's being purchased? And, you know, how is it not a loan? I think you
Thank
get where
you.
I'm coming from. Like, how do you explain that?
So great
Yeah.
question. And Chris, you want to answer both generally and if there's any specifics of Virginia that you're familiar with, we would answer that.
Yeah, I think it's going to be a general answer. No matter what state you're in. But I when I'm talking to attorneys, and if you've been to law school, everybody kind of has heard the bundle of sticks argument. I always start out like saying, think of this as just one little stick that you're selling us. And what that stick is when a will has been written already and the person dies. At that moment they die, your interest vests in that will. You have a vested property right at that moment. It hasn't been it has to go through probate, but we consider that a vested right to inherit at that moment. You have a right to get that. So you're selling us that right in exchange for an upfront payment. It's just that, as simple as that. Vested right to receive money from the estate. We're not going to do it before someone died because it's not vested. But at that moment, we consider that a right that's vested into someone. Just like a payable on death account, right? I mean, it's sort of the same thing but it doesn't go through probate and we don't advance on those for a few reasons. But yeah, I hope that makes sense. I mean, it really is just, you know, I don't know. I'm trying to think of another example, but
Well, so let me just ask to help clarify, in whole or in part, right? So someone might be inheriting an estate worth $1 million. You can
Right.
buy the whole, or more commonly, you're going to buy a small part of the whole from them, right? They have $1 million coming. You're going to advance them 10,000 or 100,000 against a $1 million estate.
right. Yeah. More often than not, we're not going to advance so that we can encumber their entire interest. It's more like, okay, Aunt Sally says you get 50,000. All right, well, we're going to do a $30,000 assignment and give you 15,000. So at the end of the day, you already got your 15. When they distribute to you, you'll get 20 and we'll get 30, if that makes sense. You can, however much you want, we allow that. But I don't think there's case law on this. I'm not saying but it's taking real estate principles sort of that we've learned and applying it to just property rights. I mean, you can have a right in any property. You can have a right to receive money, like accounts payable. Like I have a right, you sell accounts payables, like you have a right to be paid on this invoice in the future. I mean, it's sort of the same thing. That's how we treat it.
Right.
That's how we talk about it.
I used to have a business and we were selling electronics. We had a huge contract for us at the time. A company's wanted to pay us $200,000 for product that cost us $100,000, but we didn't have the $100,000. And so we went to a company that advanced the $100,000 to the vendor. They took title to that invoice from our customer. The customer then paid them, and then we got the difference at the end. So we got our 100,000 profit less the fee that this company got. So that's called factoring. And there's a whole industry in different businesses that factor money that's coming in. And this is really, I think, the impetus of where this advances come from.
Yeah, and we don't charge interest. If you read through their contracts, like there's no interest charge. There's tranches based on dates of maturity. So if it takes, this is just off the top of my head, after we advance you on day one, after 60 days, the amount that we would receive on distribution is this amount. And the longer it takes, the more of that assignment we're allowed to take. It looks a lot like interest, but it's not interest.
Right.
And so there's this, like, people look at it and they're like, it's a loan. And I'm like, no, it's not. It reminds you of a loan, but it's not a loan. And when you break down the mechanics of it, it doesn't operate as a loan at all. We're not governed by any regulations with loans at all because of that legal concept.
And that's why they're very careful to say that it's not a loan. Don't refer to it as a loan. Don't use the word loan. In fact, I'm going to edit out the word loan on this video just to make sure that Christopher and the word loan aren't in the
Right.
same YouTube video, just for his protection. Right.
Now we are thinking about getting into the business of inheritance loans. We're not there yet, and we don't have a product, but it's whatever. But there might be another space where maybe there is a reason to do an actual loan and maybe to the estate, for whatever. Right? But the inheritance advance product is not a loan. It's a sale, transfer, and assignment of a vested right to property.
And for those listening, when I've
Please, right there.
researched these advances, the average cost to the consumer is about 30 to 40%, depending on the company, per year.
We are
Which
the lowest.
sounds
rated.
like a lot. I'm sorry?
We have the lowest rates of all of the advanced companies, like
I think so.
not interest.
But
yes.
But even generally, they're all in the kind of the similar range of 30 to 40% if you look at it like a loan. But what you don't factor in is the cost is different than a loan where Bank of America just sends you a statement, you make a payment, there's a credit. In this case, they have to file legal papers, they have to watch legal papers, they have to understand the documents along the way. So it is a little different. And I think a fair price is what a customer is willing to pay a vendor without being coerced. And so you have to really understand the product before you analyze, I think, and make a judgment. That's my experience.
And
Matthew Price.
There's also an end date to this growing amount, if you will. After 1 year,
Correct.
the amount will never get more. Whereas a loan on an
Correct.
interest, that'll keep accruing in perpetuity. You know what I mean? You know,
Right.
So,
Which means if you make a mistake, like I have a case right now where I was going to send a file to you, but I'm not because the petitioner didn't really want to sell the property. Well, if you advance the money and doesn't sell the property and lives there for 20 years,
right.
you know.
Yeah, well, we actually have in our agreements, you will sell the property within 1 year. So
What happens if they change their mind or want to fight you on that? I mean, what can you do?
breach of contract. I mean, or we say, listen, this is not what you agreed to. If there's some other way you'd like to pay us, I don't know. We've had people offer, like they decide halfway through the administration, oh, we want to keep the property sentimental, blah, 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 when they already agreed to sell it. All right, well, if you get a loan and pay us with the loan, maybe we don't care. There's a reality of it too, you know, but it's there for a reason, for the situations where people don't want to play ball and they want to keep the house and not pay us, right?
Interesting. I didn't know that. So maybe I should have pushed this one to you sooner because he's going to have to sell. He doesn't want to. I just want to be the guy that brings you the file where the guy doesn't sell, right? And I've been in court where your local competitors are there. It's like a 5-year case. I think, oh my God, if I advanced that money 5 years ago, I'd be so pissed.
Right.
Because they don't accrue past that first year or whatever in that case. So, okay. Matthew Price, let's get you in here. You have a question, waiting patiently. What's going on?
Yeah, Chris, good seeing you.
Matt.
My question is that if you do advance the money and the property doesn't bring what it's supposed to in order to pay off any previous liens like the mortgage or anything, do you file a lien against that, or do you just go ahead and say, okay, well, that's a loss. The estate's going to have to make it up on the personal property, or it's going to have to make it up in some other way?
I would say the answer is, if everything that was told to us at the beginning is true, no one lied to us, we're not filing any liens. We're writing it off. If if there's not enough assets generally, because we're not advancing on the estate just to be paid out of the real estate unless that's the only asset. We don't care where the money comes from. If you get it from your Wells Fargo account, you sell the 3 Toyotas, we don't care. But if that's the only asset, we're getting paid from it. But if the liabilities exceed the value and nobody lied to us, that's our problem, and we're stuck with writing that off. We're not going to file a lien on that.
Okay.
Yeah.
Thank you.
It's there's such an inherent risk because of the fast-paced nature of underwriting that, you know, if no one lied to us and at the end of the day someone missed, you know, this has happened. The estate attorney, when we were advancing, missed a $90,000 medical lien from the state. Missed it. Had no idea. Nobody lied to us. But at the end of the day, that medical lien came up and the value of those liabilities exceeded the property. And I said to my CEO, better write this one off because there's no one to sue and there's no blood to squeeze out of any stones, you know?
Yeah, I had one where the property was worth $290,000, but the Medicare lien or Medicaid lien was
Right.
$394.
Right.
So we had to write that off.
Yeah, and once you get in the world of like liens and security interest, then you start looking more like a loan and a mortgage, and we don't want to look anything like that. So
Yeah.
it's almost
Yeah.
the cost of doing business in those situations to keep ourselves looking kosher too.
Thanks, Matthew. Yeah, and I think this field, they're very concerned with the public opinion and the judge's opinion. The judges can pretty much do whatever they want. I mean, I know legally that's not the right thing to say, but in reality, if you're in the courtroom every day, they can pretty much do whatever they want. Now, you can appeal and get them overruled. That's a nightmare process to go through. And yet, when you do business in a jurisdiction, you don't want the judge to be having a grudge from one matter to the next one, because then you're going to be in trouble. And so I think the industry is very careful, not just this InheritNow, but in general, very careful to maintain a positive image with consumers and I think with judges as well, which is well said.
Yeah,
We've got a great question. I'm sorry.
I was just going to add one little thing. I think in the probate space, the judges are so deferential to the family members, executors, because most of the time these people are doing it without attorneys. They understand the emotions. They allow so much more BS than otherwise I've experienced in civil courts that are general. So it's just, you're in that space too. So
Yeah.
be nice,
What great question on YouTube from Roy Morales. How are you then compensated for the advances, or is it you're assigned to that particular probate?
I'm sorry.
How do you end up getting paid? How do you end up getting paid back? You advance money to an estate. How
Right.
do you get your money back?
The estate will distribute directly to us 99% of the time. Like, we filed our notices, so the estate attorney is aware, it's on the court file. We've communicated with them and said, hi, here's the assignment agreement. Please be aware that you should distribute this amount. Almost most of the cases, the estate just respects the agreement, which is, to me, honestly, wildly lucky for us. Because when you think about it and you break down the relationships, InheritNow really only has like 1 foot in the estate circle. Heirs are in, here's the circle, the executors in the middle controls everything, all the heirs are around and they have certain rights and they'll get notices. We have 1 foot out of the circle and only 1 foot in because we have a relationship with the beneficiary in the circle. So we are a lot relying on just good faith, respecting our contract. Now, I've never had to pull this before, but I always have in my back pocket against an estate attorney or executor who, if they want to cause an issue, hey, you don't pay us, you're intentionally interfering with your contract. That's a tort. We'll sue you for it. I've never had to do that, but it's in my back pocket because that's really what it is. They're respecting a contractual relationship that one of the heirs made with us. Now, there is a bit of leverage there. There's this term called interested person, which most probate codes have a definition for. That's generally creditors, or, they're not anticipating advance companies because that's no legislature anticipated us. But there's this category of persons who have certain rights less than others. And so, at times I'll exert leverage as much as I possibly can to just say, hey, you not giving us the money is going to cause you more problems than it's worth. Just respect the contract. But yeah, the short answer is the estate just gives us the money. They just write us a check, and we oftentimes will sign a release saying estate distributed money. We release them forever.
California, you filed your notice for the advance, and then you get notices of any changes. At some point, they propose a distribution. I imagine you're checking to see, are you on the list to get money or not? If you're not, you could object theoretically. And if you are on, then you're going to let it go and you're going to get paid. And that is a pretty smooth process, I would think, in California.
Yeah, California, I'd say almost once a week, I take a look at a petition for final distribution that someone sent over to me. And yeah, that's a great one. There's other states where, like, you don't even have to file those things sometimes. You don't have to even tell the court what you're doing.
Right.
And I have to go tell my underwriting team, like, hey, just so you know, when you advance in this state, I have no ability to find out XYZ until, we don't get paid, right? Like, so that's a challenge. But yeah, California is the gold standard for all of this process and protections for both the consumer and for us.
And I think
Except
those
for your BS foreclosure process. I'm used to, I think I said this to you, I'm a Northeast guy. It blows my mind, these non-judicial foreclosures that California allows. Like, you could just foreclose on a property in like 2 months without even going to court, where I'm used to, like, there's a court case for like almost every foreclosure in Pennsylvania. So that blows my mind.
Well, it's changing in California. Our non-judicial are looking more like judicial foreclosures
Good.
all the time.
Good.
Well, good and bad. I think the problem is going to be if you don't let people foreclose on loans. The market's been great for lenders. There have been a lot less foreclosures, but as soon as lenders start losing money, they're going to stop lending because they're going to realize they can't foreclose. And it's, I think it's a real problem brewing, but that's a whole nother discussion. Okay, hey, we're coming up in the hour here. I really appreciate those who participated. Christopher, thank you so much. I love working with your company, and you and I did an interview previously, but thanks so much for coming on and sharing with everybody today. I really appreciate you doing that. I know you're not the point of contact, but if you're interested in advanced services, InheritNow is the company, and or if you have questions on inheritance, contact me, and I'm coordinating real estate agents with them. Also, I have getprobate.cash on Wednesdays, 8:30 a.m. Pacific time, that we go over that in detail. But Christopher, thank you so much for being on the call today. I really appreciate your time.
Yeah, thanks, Bill, for having me. Appreciate it. Thanks, everyone.
Thank you.
And for the rest of you, if you're local in Los Angeles, it's almost 5 o'clock. At 6:30, we have the LA County Real Estate Investor Association meeting in the Culver City area. I motor just south of the 10 freeway at the Iman Center. I'm a vendor there, and I hope you're there and come by and say hi. If not, we do Probate Weekly every Thursday, 4 p.m. Pacific time, 7 p.m. Eastern. Sorry for the drama with the audio today. I'm not sure what it was, but thank you for suffering through it. Thanks to those who participated and asked questions, Matthew and a couple of the others of you on the YouTube. And Jess, thanks for stepping in and pitch hitting. Make it a great week. We'll see you guys soon. Bye-bye.